As most of you already know, we've been engaged in litigation against the DOJ and ATF over our FRT-15 forced reset trigger.
And would not alter the classification of a pistol or other firearm.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
The ATF is trying to set the groundwork to ban all semi-automatic firearms by redefining what a semi-automatic trigger actually is.
ATF lawsuit loss over force reset triggers. All right, imagine the ATF, the big government agency in charge of regulating all things related to alcohol, tobacco, firearms, and explosives, right? They're like the referees of the gun world, making sure everything's playing by the rules. Well, they had this grand plan to tighten the grip on force reset triggers, these nifty gadgets that caught their attention. So the ATF started flexing their regulatory muscles, gearing up to treat these force reset triggers like they were full-on mash guns. They thought they had the law on their side, ready to enforce strict rules and regulations just like they do with the big guns. But, and here's the juicy part, it didn't quite go as planned. Enter Judge R. Connor, the legal hero in this story. He looked at the ATF's plans and basically said, "Hold your horses, ATF, you might be going a bit too far here." It was like a legal slap on the wrist. This ruling put the brakes on the ATF's ambitions to regulate force reset triggers left, right, and center. Now, why is this such a big deal? Well, it's like a heavyweight boxing match, with the ATF aiming to lay down the law, but suddenly finding themselves blocked by this ruling. Judge R. Connor's decision wasn't just a tap on the shoulder, it was a full-blown roadblock for the ATF's plans. Here's where it gets interesting. The impact of this ruling wasn't a total shutdown of the ATF's power trip. Nope, it was specific, directed only at certain folks involved in the case and members of NAGR, the National Association for Gun Rights. It's like Judge R. Connor said, "Hey, you can't play hardball with these specific people and NAGR members under these rules." This ruling, though limited in scope, shook things up. It wasn't just about these triggers anymore, it was about reining in the ATF's authority. It questioned whether the ATF was stretching their powers a bit too much, you know? It's like a reminder to them that they can't just run amok with these interpretations of the law. So, what's the aftermath of this legal shakeup? It's like a temporary ceasefire, a timeout for the ATF's plans to regulate force reset triggers. It's a win for those specific folks involved in the case and NAGR, but it's also a reality check for the ATF, making them reassess their strategy. But wait, this legal drama ain't over. The ATF's probably flipping through law books right now, planning their next move, most likely an appeal to the Fifth Circuit Court. They're not the type to just take a loss and call it a day. In a nutshell, this ruling's a big deal. It's like a pause button on the ATF's plans, a temporary win that's got everyone on the edge, wondering what's next. Will the ATF bounce back, or will this ruling stand its ground? It's a game of legal chess, and right now, the pieces are in motion, waiting for the next move. ATF versus rare breed triggers. Buckle up for this roller coaster legal saga between the ATF and rare breed triggers. It's been a whirlwind of lawsuits bouncing around different courts, and the outcomes? Well, let me break it down for you. So picture this. Rare breed triggers caught the ATF's attention, especially their force reset triggers. The ATF, being the rule enforcers they are, decided these triggers were playing a little too close to the mash gun rulebook. That's when the legal rumble began. First off, the lawsuits were flying left and right, landing in courts in both Florida and Texas. Florida was the initial battleground, but there were some hiccups along the way. Filing errors from both rare breed triggers and the ATF led to the case getting thrown out. It was like a false start in a race. They just couldn't get the legal engines revved up properly. But hold on, that's not the end of the story. Fast forward a bit and boom! Rare breed triggers partnered up with the National Association for Gun Rights and took their fight to Texas. Now, Texas isn't one to shy away from a legal showdown, and this time, they got Judge R. Connor in the ring. And let me tell you, Judge Connor's become a bit of a hero against the ATF in a few legal bouts. Now here's the kicker. The outcomes of these different court venues weren't playing the same tune. Florida said, nope, sorry folks, errors on both sides, case dismissed. But Texas? Texas was a whole different ballgame. Judge Connor's court was like, hold up, let's dive deep into this ATF versus FRFRT business. And that's where things got spicy. In Texas, Judge Connor wasn't having any of the ATF's high-handed approach. He put a halt on the ATF's plans to enforce those FR/FRT rules, saying, "You're stretching it too far, ATF." It was like a beacon of hope for rare breed triggers and NAGR, a legal win that Florida couldn't deliver.
As most of you already know, we've been engaged in litigation against the DOJ and ATF over our FRT-15 forced reset trigger.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
ATF has a history of reinterpreting federal law in an attempt to expand what firearms and accessories are illegal. The ATF is trying to set the groundwork to ban all semi-automatic firearms by redefining what a semi-automatic trigger actually is.
So you've got Florida dismissing the case due to filing bloopers, while Texas, under the guidance of Judge R. Connor, served up a legal curveball that put a wrench in the ATF's plans. It's like two courts playing different tunes in the same concert, leaving everyone scratching their heads about what's what in the legal world. And that, my friend, is the tale of these legal battles. Same parties, different courts, and outcomes that are as different as night and day. It's like trying to solve a jigsaw puzzle with pieces from two different sets. Confusing, unpredictable, and definitely not your average legal drama. Court orders and preliminary injunctions. When Judge R. Connor stepped onto the legal battlefield, things got mighty interesting. His decisions weren't just legal rulings, they were seismic shifts in this whole ATF versus FR/FRT saga. So picture this scene. Judge R. Connor, this legal maestro, stands at the center of the courtroom. He looks at the ATF's plans to enforce those FR/FRT regulations and thinks, hold on a second, we need to put a temporary hold on this. And that's when the magic happened. Preliminary injunctions were the name of the game. These injunctions were like a legal shield, a force field that the judge threw up to protect certain players in this legal dance. But here's the twist. It wasn't a blanket cover for everyone in the gun-owning community. These injunctions were laser-focused, targeting specific plaintiffs involved in the legal showdown against the ATF and the members of NAGR, who were standing shoulder to shoulder in this battle. It's like Judge Connor drew a line in the legal sand and said, "You folks, you're safe from the ATF's regulatory storm, for now." It was a limited shield, a legal armor that covered only these specific individuals and NAGR members, while the rest of the gun-owning world watched from the sidelines. Now, why is this such a big deal? Well, imagine you're part of this legal tussle against the ATF, and suddenly, Judge Connor's legal shield swoops in to protect you from the ATF's enforcement actions. It's like a temporary relief, a momentary pause in a situation where the ATF was looking to crack down hard. But here's the thing, it's not a permanent victory. It's more like a timeout in a heated game. These specific plaintiffs and NAGR members are under this legal umbrella, shielded from the ATF's immediate reach. But it's not a long-term solution. It's a strategic move, a legal chess piece that's bought them some time in this back-and-forth battle. The rest of the gun-owning community, though, they're still navigating this murky legal waterscape. It's like Judge Connor shone a spotlight on these specific folks while leaving the rest in this hazy uncertainty, waiting on the edge to see what comes next in this legal saga. These preliminary injunctions were like arrows aimed at specific targets in this legal bullseye. They created a bubble of legal protection for a chosen few, shielding them from the ATF's immediate actions. It's a temporary win, a brief respite in the storm, but the larger picture of how this legal chess game plays out, well, that's still hanging in the balance. Judge Connor's moves weren't just legal jargon, they were strategic maneuvers, carving out a legal sanctuary for a specific few, in the midst of a broader regulatory storm. Judge R. Connor's decision rationale. Let's dig into the thought process behind Judge Connor's pivotal decision to grant that preliminary injunction against the ATF's regulation of force reset triggers. His reasoning was like a roadmap, guiding us through the legal jungle of this ATF versus FR/FRT showdown. First off, the legal basis. Judge Connor wasn't just throwing darts blindly. He had some serious reasons to slam the brakes on the ATF's plans. See, he looked at the situation and said, "Hold up, ATF, you might be stretching it a tad too far." His reasoning wasn't just a gut feeling, it was grounded in legal logic. Judge Connor peered into the laws and regulations and saw potential concerns. He believed that the ATF's interpretations of the rules was a bit too broad, like trying to fit a square peg into a round hole. He raised questions about whether the ATF was reading the statutes in a way that was a bit of a stretch. And here's the thing. He wasn't saying the ATF was totally wrong, but rather he had concerns that they might be overreaching their authority. It's like saying, hey ATF, you might need to rein it in a bit.
And NAGR is filing a suit in the Northern District of Texas to put a stop to their overreach.
And would not alter the classification of a pistol or other firearm.
That I'm working with the National Association for Gun Rights and Texas Gun Rights to bring a new legal action against the ATF. The ATF has a history of redefining absurd objects as machine guns.
Statutory overreach was the name of the game here. Judge Connor was waving a caution flag, warning that the ATF's interpretation of the law might be like a horse galloping at full speed when it should have been trotting cautiously. He looked at the situation and thought, the ATF's interpretation might be beyond the scope of what's allowed. It's like he had a magnifying glass on the fine print of the law and saw potential gray areas where the ATF's plans might not fit snugly within the boundaries. So when Judge Connor granted that preliminary injunction, it wasn't just a random decision. It was like him saying, I've got concerns, ATF, and until we sort this out, let's hit the pause button on your plans. He wasn't denying the ATF's authority outright. He was just asking for a little legal clarity. It's like asking the ATF to double-check the rulebook and make sure they're coloring within the lines without stepping outside the legal boundaries. Judge Connor's decision wasn't a no to the ATF. It was more of a, hold on, let's double-check the rulebook before we proceed. He was like the legal traffic cop, directing the ATF to pump the brakes and reassess their interpretation before charging ahead. His rationale wasn't just about stopping the ATF, it was about ensuring they were on the right legal track. It was a moment of legal caution, urging the ATF to reconsider before taking any further steps into the regulatory territory. That's the gist of Judge Connor's rationale, a call for legal caution and a reminder to ensure the ATF's interpretation falls within the statutory lines. ATF's attempted stay denied. All right, let's unravel this bit where the ATF was hoping for a lifeline in the form of a stay on the injunction, only to have Judge Connor slam the door shut on that request. So picture this. The ATF, after hitting a speed bump with Judge Connor's preliminary injunction, decided they weren't ready to throw in the towel just yet. They wanted to hit the pause button on that injunction, seeking a stay to keep things on hold while they geared up for an appeal to the Fifth Circuit Court. It's like the ATF saying, hold on, Judge, we need a breather while we figure out our next move. They wanted to freeze the action, putting a temporary hold on Judge Connor's injunction, hoping to buy some time to appeal the decision higher up the legal ladder. But here comes the plot twist. Judge Connor wasn't having any of it. Nope, he waved away the ATF's plea for a stay faster than you could say appeal. He put his foot down and said, sorry ATF, no stay for you.
Do arm braces make firearms more powerful?
They do not. They do not.
The Nonpartisan Government Accountability Office issues a report in June of 2016, Firearms Data.
Tyrants disarm the people they intend to oppress. Those are the facts.
His reasoning? Serious harm to the plaintiffs. Judge Connor saw potential damage looming large if he hit the pause button on that injunction. He was like, I can't risk causing harm to these folks while we wait around for an appeal. It's like he looked at the bigger picture and realized that freezing the injunction could potentially hurt those specific plaintiffs who were under the shield of his initial ruling. His decision wasn't just about legal technicalities. It was about safeguarding these individuals from any harm that might come from delaying the injunction. So when the ATF knocked on Judge Connor's door, hoping for a stay, he didn't let them in. He saw the potential harm outweighing the ATF's desire for a breather. It's like Judge Connor was saying, I get where you're coming from, ATF, but these folks need protection, and I can't hit the pause button if it puts them at risk. The denial of the stay wasn't just a legal move. It was a decision rooted in protecting those shielded by his injunction. Judge Connor wasn't swayed by the ATF's request. He prioritized safeguarding the interests of those under his legal umbrella. And that, my friend, was how the ATF's attempted stay got shut down by Judge R. Connor's refusal, all in the name of preventing potential harm to the plaintiffs. ATF appeals to Fifth Circuit Court. The ATF wasn't about to let a preliminary injunction by Judge Connor put a full stop to their plans. No, sir. They strapped on their legal armor and charged forward, aiming straight for the Fifth Circuit Court of Appeals, the next frontier in this legal showdown. Filing an appeal was their ace up the sleeve, a move signaling they weren't backing down. It was like saying, "Okay, Judge Connor, you made your call, but we're taking this to the big leagues now." The ATF wanted the Fifth Circuit Court to hit the reset button on that pesky injunction, hoping for a legal U-turn that favored their side. Their appeal wasn't just a legal jab, it was a strategic move. They wanted a fresh set of eyes, a different perspective on the whole shebang, hoping the Fifth Circuit Court would see things differently from Judge Connor. But that wasn't all. The ATF also had another trick up their sleeve, a plea for a stay. It's like they were knocking on the Fifth Circuit Court's door asking, "Can we press pause on this injunction while we sort out the appeal?" Their request for a stay was their way of taking a breather, a temporary freeze on Judge R. Connor's injunction. They were hoping for a timeout, a momentary halt on the enforcement of the injunction, giving them room to regroup and strategize without the immediate pressure of compliance hanging over their heads. This pursuit of a stay wasn't just about catching their breath, it was about buying time, a pause in the legal action, a chance to reassess their game plan. The ATF was playing the long game, hoping to shift the playing field in their favor while they made their case to the Fifth Circuit Court.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
So this is a tool that's helped solve 50% of crime.
Wait. Did they have to delete 252 million records?
Everyone here understand that the brace does nothing to make the weapon any more dangerous.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
But here's where the tension ramps up. The ATF's appeal and their plea for a stay were like a legal tug-of-war. On one end, they were asking the Fifth Circuit Court to reconsider the whole situation, hoping for a legal thumbs up on their side. On the other, they were pleading for breathing space, asking for that temporary freeze on the injunction. It's like a high-stakes game of chess, each move calculated, each maneuver aimed at gaining an advantage. Whether the Fifth Circuit Court grants that stay or not, well, that's the million-dollar question in this ongoing legal drama. This appeal and the request for a stay were the ATF's way of saying, "We're not throwing in the towel just yet. We've got fight left in us, and we're taking this all the way to the Fifth Circuit Court if we have to." Their legal strategy was like navigating a complex maze, seeking relief from the injunction while they made their case to the higher court. It's not just about the appeal, it's about the interplay between legal maneuvers, hoping for a favorable ruling that tilts the scales back in their favor. So while the appeal to the Fifth Circuit Court is underway, and the ATF waits on the edge of their seats for a response to their plea for a stay, the tension in this legal battleground continues to simmer. The outcome of these moves? Well, that's a cliffhanger we're all get legal chess match. Ongoing uncertainty. The ATF's persistent pursuit of enforcing force reset trigger rules has been nothing short of a roller coaster ride, showcasing their unwavering determination even in the face of legal stumbling blocks. Despite legal setbacks, like Judge Connor's preliminary injunction halting the ATF's enforcement plans against specific plaintiffs and NAGR members, the ATF has been a dog with a bone. They're not letting go of their push to regulate these triggers, as if their enforcement efforts are fueled by sheer determination. It's like the ATF saying, "Sure, there might be legal hurdles, but we're not backing down." They've been steadfast in their attempts to enforce these FRFRT rules, almost like trying to fit a square peg into a round hole, even when the legal ground seems shaky. But here's the kicker, a cautionary note for folks out there in the gun-owning community. The ATF's persistence isn't just a legal tango happening in courtrooms. No, sir, it's a real-world cautionary tale. There's this looming uncertainty, this sense that despite legal setbacks, the ATF is still out there, eyes peeled for any signs of FRFRTs. It's like a warning signal, flashing bright red. Be cautious, folks, because the ATF's enforcement stance is aggressive, to say the least. Imagine you're in this murky territory where legal rulings clash with real-world actions. Judge Connor's injunction might have thrown a spanner in the works legally, but on the ground, the ATF's eagerness to enforce those FRFRT rules seems undeterred.
That is violating the law, exceeding their authority, and collecting records that they have no business collecting.
In Cambodia, The Khmer Rouge were able to take advantage of the fact that limited gun ownership.
I'll read from it. It says, a technical defect allows ATF agents to access data, including purchaser data.
So here's the thing. There's a word of caution buzzing around, advising individuals to tread carefully in this atmosphere of uncertainty. The ATF's zealousness in enforcing these rules, even amidst legal turbulence, is a red flag, a reminder to folks to be vigilant. It's like navigating through a legal minefield where court rulings clash with the ATF's boots-on-the-ground actions. There's a sense of caution in the air, a warning to gun owners to stay vigilant, be aware, and exercise caution when dealing with anything related to FRFRTs. The ATF's determination, despite legal roadblocks, isn't just a legal saga, it's a real-world concern. There's this palpable tension, this feeling that the ATF's enforcement arm isn't letting up, even when the legal ground beneath their feet might seem a bit shaky. So for individuals out there, it's like a gentle warning bell chiming in the background. Be mindful, be cautious. The legal battles might be happening in courtrooms, but the ATF's enforcement efforts are palpable, real, and potentially impactful for those involved. It's a scenario where legal ambiguity clashes with practical actions, where cautionary notes echo amidst the legal complexities. The ATF's persistent efforts to enforce FRFRT rules might be like waves crashing against legal shores, but the ripples of their enforcement stance are felt beyond the courtroom doors. In this ongoing uncertainty, it's like a tale of caution unfolding, a reminder to tread carefully, seek legal counsel if needed, and be vigilant in a landscape where the ATF's enforcement stance remains assertive even amid legal twists and turns. The legal saga might have its chapters and twists, but the cautionary note rings loud and clear. Stay alert, stay cautious, in the realm where legal uncertainty meets real-world enforcement efforts. Warning and caution regarding FRFRT possession. Navigating the landscape of owning force reset triggers amidst the ATF's enforcement fervor is akin to walking a tightrope over a legal abyss. The risks associated with possessing these triggers, especially in the current climate of regulatory uncertainty, can be quite significant. The ATF's persistent efforts to enforce FRFRT regulations add an air of caution to anyone in possession of these triggers. While legal battles and court injunctions might paint a picture of ambiguity, the reality on the ground carries potential legal pitfalls for individuals with FRFRTs. Picture this scenario. A knock on the door, law enforcement inquiries about FRFRTs. It's not just a casual conversation, it could potentially carry heavy legal consequences. The stakes are high, and that's where seeking legal counsel becomes more than just advice, it's a necessity. The legal risks of possessing FRFRTs amidst the ATF's enforcement fervor are real. There's this underlying uncertainty where the ATF stance clashes with legal battles, leaving individuals in possession of these triggers in a precarious position. That's why the advice, the cautionary note echoing in this uncertain landscape, is crystal clear. Be vigilant, exercise extreme caution, and most importantly, seek legal counsel if you find yourself in the crosshairs of law enforcement regarding FRFRTs. The importance of seeking legal guidance cannot be emphasized enough in such situations. It's about having someone with legal expertise in your corner, someone who understands the complexities, the nuances of the law in this particular realm. If law enforcement reaches out to discuss FRFRTs, the best move isn't to engage in discussions. Instead, it's about staying composed, redirecting inquiries to your legal representative, and refraining from saying anything that could potentially impact your legal standing.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms,"
to offer amendments to the Appropriations Act to zero out their salaries for breaking the law and abusing the liberties of our fellow Americans.
reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
Why the caution? Because legal repercussions in situations where regulatory ambiguity meets law enforcement inquiries can be severe. It's about protecting oneself from inadvertently saying something that might lead to legal entanglements. In this maze of legal uncertainty, seeking legal counsel becomes your shield, your guiding light. It's not just about knowing your rights, it's about having someone who can navigate the legal labyrinth and safeguard your interests. The proactive step here is seeking legal advice, being prepared for any legal storm that might come your way. It's about staying informed, understanding the potential risks, and having the right guidance if the regulatory turbulence manifests in law enforcement interactions. Remember, it's not about navigating these uncertain waters alone. It's about having someone who can steer you through the legal complexities, someone who can represent your interests and guide you through potential legal pitfalls. In essence, possessing FRFRTs amidst the ATF's enforcement efforts isn't just a matter of ownership, it's a matter of legal caution and seeking the right legal counsel. It's about being prepared, staying informed, and having the right support should the need arise in this intricate legal terrain. The takeaway? The importance of seeking legal guidance cannot be overstated. It's your safety net, your shield against potential legal repercussions in a landscape where legal uncertainty meets the ATF's assertive enforcement stance regarding FRFRTs. That's all for this video, folks. See you next time.